I'd like to bring this August 15th, 2022 Planning Board meeting to order, please. Before we stand for the Pledge of Allegiance, Mr. Fink, I would like for you to stand up, and I'm sorry I haven't gotten over and shake your hand, but
That's okay.
Dan Fink, he's going to be alternate number 2 going forward on the Planning Board. So thanks a lot for willing to serve, and we'll get you in here. All right. Will everybody please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Wes, you don't have any changes to the agenda, do you?
No, sir.
Anybody? I would entertain a motion then to approve tonight's agenda.
I'll make a motion to approve the agenda for August 15th, 2022.
I'll second.
Thank you, Linda. All in favor?
Aye.
Aye. Opposed? None. Okay, next item is approval of minutes. Does anyone have any corrections, additions, subtractions of the minutes?
That was good this week.
I had, Wes, just a kind of a housekeeping thing with the minutes, and that was, let me find mine here. That was on page, the very first page, under call to order. Probably need to note in there that Jan sat in for Robert as a voting member.
Yes, sir.
Okay. And then I think it would be appropriate, let's see, under, on page 3, line 133. Or actually,
That's blank on ours.
yeah, that's funny. Yeah, you just printed these out. Strange, that was the line I was.
Well, I don't know, remember the formatting that you've printed on before previously didn't match up with the ones that I've been printing here.
Yeah,
I know we ran into that
Yeah.
issue before.
I just looked at it a couple hours ago on Word, I think, and 133 was there. But anyway, the gist of what I would like to see would be the content of the email that I sent to town council probably needs to be in the minutes. So it was up on the board.
Okay.
It was read into the record, but I think it would be appropriate if the content was in there. Beyond that, I don't have any other corrections. Anybody? I would take a motion to approve minutes with corrections.
I'll make that motion.
Thank you, Ed. I'll second. Any discussion on that?
Yeah.
All in favor of approval of minutes with the corrections, say aye.
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 Opposed, none. Okay.
I do have one comment about the minutes, not this minutes, the previous month's minutes. They were continued. We did not approve them.
Yeah.
What is the status of that? You know?
We'll have them for approval at the September regular meeting.
Okay.
Yes, sir. Thank you for reminding me.
Yeah.
Okay. Anybody signed up for a public comment?
I'm aware of.
I haven't signed up, but I'd like to make a comment.
Absolutely.
Normally, I'm not on this side doing this.
Feels good, doesn't it?
But good evening, Chairman and the rest of the board. I'm here and my name is Leo Holland. I live at 23 Spindrift Trail. and I'm also a town council member. Well, I want to just get into the record tonight, the discussion y'all had last month regarding the council's lack of, for a better term, response to the chairman's email of 8 and 14 June. I would like to say that a council member did respond. I did not respond to the 8th of June meeting because I interpret it as not requiring a comment. When I got the chairman's email on the 14th of June, which is about 6 o'clock in the evening, I went back and reread the first one, and I did reply to the email that was for the 14th of June. I replied about 8 o'clock that night. And then the chairman did respond back to me the next day regarding the comments. And since that time, he and I have had some discussion, but I just want the record to get changed because it kind of got out that the council was ignoring the planning board, and that's not the intent. So if you could take care of that, I'd appreciate it. And I don't have any other further discussion. And thank you for your attention.
Okay, thanks, Leo. Thank you. Anyone else that hasn't signed up wish to speak? None seen. We will go to old business, which there is none that I'm aware of. Any old business, Wes, that we need?
No, sir.
Okay. Then going into new business, we have 2 ZTAs before us tonight and discussion of quasi judicial procedure. We are going to start the first ZTA 2209 submitted by Mila Smith to amend Town Code sections 36, 163, and 36, 207B3. Wes, can you give us a brief overview of that?
Yes, sir. Thank you. Good evening, Mr. Chairman and members of the board. This application is an amendment to sections 36-163, off-street parking requirements, and section 36-207B3, service establishments. And the purpose of the ZTA is to allow group fitness, aerobics, dance, karate, yoga as a permitted use in the C General Commercial Zoning District. The proposed amendments to section 36-207B3, that's what actually establishes the proposed use, which would allow various group fitness service establishments. The proposed amendments to section 36-163 establish the minimum parking requirement for the proposed use, which requires 1 space for each 250 square feet of gross floor space. As a permitted use, such establishments could be approved administratively if they are proposed to be located in an existing building and a site plan is not required. If a site plan is required, it would have to be reviewed by the planning board and the town council. With respect to the land use plan, town staff found that policy 2 is applicable. Town staff determined that the amendments are consistent with the town's currently adopted land use plan, and the town staff recommends that the board recommend approval of the application to the town council. I'd be glad to answer any questions you all may have. I will say, as a side note, Mr. Chairman, you brought this to my attention. In the ZTA, there is a reference to conditional use permit, which, as you all know, recall that we did amend all of those references. So on line 4, page 2 of ZTA 2209, that actually should say special use permit. And that's not any of the language that's subject to change or being proposed to be amended. But I'm glad you brought that to my attention. And if and when it's codified, we will revise it so that it states special use permit.
Thank you, Wes. Would Ms. Smith like to speak?
Hello, thank you for having me.
Well,
We've been on the beach running our dance studio for 27 years. And I'm here tonight to appeal to you all to hopefully we can relocate to Southern Shores. The Dare Center has been a very good home for us for all these years, but we're just looking to maybe move to a safer, a unit that actually functions properly. And the majority of our dance families live in Kitty Hawk and Southern Shores, so it'd be really convenient for them as well. We are an after-school program, so our girls come after school, and then we go until about 8:30, 9 o'clock at night. The younger elementary kids come first, then the middle schoolers, and then the high schoolers. And on Friday mornings, we do our preschool program. So
Sounds busy.
we are busy.
It's great.
We're busy.
Anybody have any questions for Ms. Smith?
I'm good with it.
I think your cover letter to us hit all the high points, and I don't have any resistance to it. I think the parking, I talked to Wes about the parking, and it's all the parking spaces that are required are being taken into account here, and there's more left on the site, so, or it would be. The only question I had, Wes, was if this was a standalone operation, would the parking requirement be different?
No, sir, it would still be based on the same calculation, same requirement.
Anybody else have anything
No, I
for
don't.
Ms. Smith? Well, thank you.
Thank you. Appreciate y'all.
Okay. One thing I was wondering about, Wes, in the wording, it's got group fitness dash aerobics / dance / karate / yoga. Where would, if someone wanted to do a weight training, like a small gym, how would that fit into this language?
I would say that it's similar, a gym would be similar to this use. We have our schedule of district regulations, which have all of our permitted uses and special uses. And by establishing this, that would be a similar use. If you recall, if there aren't uses that aren't specifically listed, but if there are one or more that are similar, you can apply that if they are similar. And I would say in that instance, that if someone proposed a gym, weight room, that it would be covered by group fitness.
Could we just simply add it?
We could, the board could recommend that, yes, sir.
And I'm just looking how, the sentence is pretty much composed. I was asking my wife, that's a lot better at English than I am, about where she would think gym would come in there, and she goes, well, it's aerobics. Well, not necessarily. I mean, it could be weightlifting, training. So I'm just wondering how we could maybe make the use encompass a gym or weight training facility.
You could put something, or at any point, after dance, karate, yoga, or just after yoga, exercise facility. You could say gymnasium.
If you just remove the hyphen between group fitness and aerobics and put the backslash that you have.
Or
That-
commas.
Yeah, or commas, that I think would cover it, rather than, because with the hyphen, it looks like the group fitness is considered aerobics.
Yeah.
But if you just put a comma there, then the group fitness, comma, aerobics, dance, et cetera, I think
Yeah.
that's probably the easiest way.
Yeah, that's what I was thinking, is just put commas
Okay.
right on down the line, and after yoga, put another comma, gym and or weight training.
Okay. Yes,
If
sir.
that makes sense to everybody. We don't want to leave out Pilates. Where does that fall in?
Group exercise. That's group
That's
exercise.
group
Okay.
exercise or aerobics.
Yeah, or sometimes.
You could also change karate to martial arts, perhaps.
Yeah, that's-
Yeah,
Yeah, that's a good
Yeah.
idea. Yeah.
okay. Is
Not
that,
to include axe throwing.
no, that's right. Is that too substantial of a change to put in the recommendation to the town council?
The board can make recommendations, and
Yeah.
I think that would be appropriate.
I would say that would be
Yeah.
fairly encompassing.
yeah, that should be.
It'll save a problem in the future.
Yeah. Yeah, I kind of wonder about telephone switching stations in there. Anybody see that one, Ed?
Yeah.
When was the last switching station we've had here in Southern Shores?
I couldn't tell you.
Anybody else have any concerns or heartburn about what Ms. Smith is proposing? I would entertain a motion to,
Mr. Chairman, I'm sorry, if I may, can we see if anyone has any comments specific to this application?
sure,
I think Ms. Schursma has.
okay.
Since you started talking about language, Ann Scherdsma, 232 North Dogwood Trail. It bothered me too, what you're talking about, and seems to me one way to go about it is just to say group fitness and dance, and then define fitness in your definition section, and elaborate all the various martial arts, yoga, karate, etc. And I also wonder why it is we don't already permit some of these facilities, because I thought we had something in the Southern Shores Crossing that amounts to a gym. And that certainly was a group fitness center, to my understanding. So was that a conditional permit?
I do not know.
Yeah, it seems like we already have it on record that they're permitted. And again, I don't understand the one parking space for 250 square feet of floor space. That doesn't make any sense to me. You know, if you had all these kids with all their parents parked outside, you'd need a lot more than just one parking space for 250 square feet. So that's kind of illogical to me, especially when you start talking about a standalone facility but the Southern Shores Crossing seems like an obvious place to put this kind of facility, but not necessarily in the future. Thank you.
Anyone else from the public like to comment before we vote? For motion and vote? Anybody? No. Anybody want to put a motion out on this to
Yeah.
approve with what we just spoke to?
Yeah, I'd like to make a motion to approve ZTA 2209 with the not corrections, but the addition noted of the commas between and gym. I believe that was what we encompassed,
Gym and/or weight training.
gym and/or weight training.
I'll second.
We
Thank you.
include a finding of consistency with the land use plan. Do you want that?
It's included in the ordinance. If you want to make a separate recommendation that it is, you can do that as well. But it's one of the articles. It's Article 4 of the ordinance on page 3.
Okay, so I don't think it's necessary, sorry.
Okay. And it's already implied, right?
It's implied in Article number 4.
Okay. All right, we have a motion and a second from Tony, second from Linda. Any discussion? All in favor of the motion to approve this and send it to town council, please say aye. Raise your hand.
Aye.
Any opposed? None seen. Okay. Thank you, Ms. Smith. And I'm sure you'll be a good neighbor. I've known a lot of little girls that have come through your facility, and I'm sure there'll be a lot more. Okay, well, good luck.
Mr. Chairman,
Yes.
I've got another meeting at 7 o'clock I want to go prepare for, and the rest of the agenda doesn't really apply to me, so I'm going to excuse myself.
Okay, thank you, John. All right, thank you.
care, John.
Next item under new business is P1, which is a preliminary subdivision plat. Wes, can you give us a synopsis on what we're looking at here?
Yes, sir, Mr. Chairman. The next item on the agenda is a subdivision request from Matthew and Allison Casella. And the requested action is approval of preliminary subdivision plat for 267 Hillcrest Drive. The property is zoned RS1 Single Family Residential. The existing land use as determined or established on the town's current land use plan is residential. With respect to the property's surrounding land use and zoning, it is residential and all zoned RS1 residential. Physical characteristics, currently it's one parcel and it's considered developed. Applicable regulations are Chapter 30 subdivisions, Town Zoning Ordinance, Article 3, Interpretation and Definition of Terms, Article 4, Application of Regulations, and Article 7, Schedule of District Regulations. The town's subdivision ordinance establishes a review process for subdivisions that require planning board review and recommendations on all preliminary and final subdivision plats, except for exempted subdivisions. The applicant is requesting to subdivide the lot located at 267 Hillcrest Drive into two new lots. The existing single-family dwelling and other improvements currently situated at 267 Hillcrest Drive are proposed to be located on new Lot 1B with a lot size of 70,360 square feet, and the remaining property is proposed to be located on new Lot 1A with a lot size of 52,016 square feet. Both lots as proposed meet the town's minimum lot size requirement of 20,000 square feet and lot width of 100 feet. Both lots also meet the town's frontage requirement by providing at least 30 feet of frontage that abuts a public right-of-way or private street. Town staff recommends approval of this preliminary plat with the following conditions. The exemption certificate shown on the preliminary plat shall be deleted. A certificate of approval by the planning board shall be added to the final plat, and a certificate of approval by the town council shall be added to the final plat. There are instances where there are exempt subdivisions or recombinations that don't require planning board and council review. If you recall, we did amend the ordinance not too long ago to allow for an expedited review that can be approved administratively. However, there were certain criteria that the property had to meet. And in this case, this does not fall within the criteria as far as the lot's size, as well as it can't be considered exempt due to the lot size. So unfortunately, it's a longer approval process. It's it's two lots. From staff's perspective, it's pretty straightforward, but it does require a preliminary plat review by the planning board and council and a final plat review by the planning board and town council. I have the plat shown up on the screen. Clearly, you can see Lot 1A, 1B, the areas, the widths at the street, 102.63 at the street, and 100 feet as you go back further. And you can see that they clearly meet the 30-foot of frontage along Hillcrest Drive. With respect to the existing structure, you can see that the side setback and front setback requirements are satisfied, and there aren't any lot coverage issues either due to the lot size. That concludes my information, Mr. Chairman, if you have any questions.
Thank you, Wes. Let's see. I guess first off, are the Casellas here tonight? Would you like to speak to what your endeavor entails?
Sure.
You don't have to, but.
Okay,
I'll introduce myself, please.
Great.
Thanks a lot. I'm not the, I don't think I got an A in public speaking in college, but I appreciate y'all's time. And basically what I've tried to do here is a very conservative subdivision of this property. As you can see, it's a lot of land. My goal with it is to have some property. We live here. I live in Chickahawk, and I'd like to be able to have some land so that when my kids get older and they want to live back here, I've got something for them, because the cost is getting pretty high to live here. So that's my whole plan with this. So that's really what it is. But it's 2 lots, conservative outlook on it, and I really appreciate y'all's time. And I know if it were like less than 2 acres and more than 5, I wouldn't have to take y'all's time with this. But since this falls into that zone, I appreciate y'all's time. And if you guys have any questions, or ladies have any questions, I'll do my best to answer them. So.
Anybody have any questions of Mr. Cassell?
What happens, I see you have a well there. Is that a functioning well?
I haven't had it looked at. I do not believe it's functioning at this time. That's all the way down at the very bottom by the shed.
Yeah.
I haven't had it tested yet to see if it's functioning. But that's a great question. I'll look into
I
it.
mean, if it's not, I would suggest that it be abandoned according to state standards. Because if you decide to sell that lot, don't build it for your kids, and you decide to sell it, there's some potential liability
Okay.
with that well. If it's not functional, then it should be abandoned properly.
All right. I appreciate that. There is a pump there, and I just need to have a mechanic look at that. Thank you.
Anybody else have any questions? Do I need to let the public weigh in on this one? Wes,
Yeah, sure.
would anybody care to speak to this endeavor? None seen.
Okay.
Let's move on. About subdividing almost 3 acres of land here and turning it into 2 lots that are still large. The only thing that Wes and I talked about was, and it's in his report, is getting rid of the exemption certification, and that's just a matter of taking it off the plat.
Correct.
Anybody have concerns here?
No.
Well, I would entertain a motion to recommend preliminary approval of this site plan to town council for their preliminary approval. And then I guess we get it back again, don't we, on the
Yeah.
final plat?
Yes, sir. Assuming that the preliminary plat is approved by council, then the final plat would come back before you all.
Right, okay. Can I get a motion to approve this for a recommendation to council?
Yeah, I'll make a motion that we approve how it's stated here with the removal of the platted exempt from town of Southern Shore Subdivision, have that removed, and then forward it to town council for their preliminary approval.
Thank you, Tony. Could I get a second on that motion?
I'll second.
Thank you, Linda. We have a motion and a second. Is there any discussion? None seen. All in favor of sending this on to town council for their preliminary recommendation, say aye.
Aye.
Opposed? None seen. Okay. So Wes, will town council have this on their next month's agenda,
Yes, sir.
and then it comes back to us the following month?
Assuming that they
If
can,
they get the plat?
if they get the final plat
Okay,
put together prior to then.
great. Okay. Moving into item C under new business. We have a special guest with us tonight, our attorney for the planning board, Mr. Jay Willis, and Jay is going to speak to us and give us some guidance and a few lessons on how to conduct ourselves at a quasi judicial procedure. Welcome, Jay.
Thank you very much, Mr. Chairman. And good evening to the board members. It's odd for me to be on this side when I represent you. I'm normally sitting up there next to the chair, so it's a much more comfortable position for me to be in.
We can slip over and make room for you.
Thank you. I've been practicing law 33 years in Manteo. My father was a county attorney during a time when the county was growing. He did that job for 25 years in private practice. And I, over that period of time, have come to represent a few boards myself. I particularly enjoyed planning boards, Board of Adjustments. I represent Nags Head, Kill Devil Hills, and Southern Shores in their boards of adjustment. I've been called on to represent Currituck County in some matters when they have conflicts. And I represent the Dare County Tourism Board. So I have a good base for municipal type work and public work. I understand it's been a great deal of time since your board has met as a Board of Adjustments. And because of that, Wes felt it might be a good idea. You've got a hearing coming up, maybe in the next month or so, to come before you and refresh you as to what a quasi-judicial hearing is really all about. Excuse me. So if there are questions that I can't answer while we go through this, I'll write them down. I'll get you an answer. Hopefully between Wes and I, we should be able to answer any questions. And if there aren't any, then we'll be out of here in maybe a little bit longer than the 3 minutes that I've been allotted here. So here in Southern Shores, your planning board actually functions as a Board of Adjustments as well, which is authorized under North Carolina law. I haven't polled all the other towns, but you're the only one I think that does it. The other two boards that I represent have separate boards of adjustment. Here, the Board of Adjustment hears a variety of matters, including variances, which are really the bread and butter of what you do. And there are also appeals of decisions made by town staff or administrative officials. It's broken down in terms of appeals to denials of permits or applications, the town's issuance of notice of violations for a use that does not meet with the current ordinance, or the issuance of a formal interpretation of the ordinance that you have. The hearing that we follow in variances and in these denials of various rights that the public may have are very much courtroom oriented. There's a presentation of evidence, sworn testimony, substantial evidence presented by written documents properly authenticated through a witness that might know something about the particular document to get it into your hands to review. Unlike a variance, all decisions in an appeal, like you might have before you next month, would be by a 3/5 majority. Variances are 4/5. An appeal from a decision of one of your town officials is similar to, but not quite like, a variance. Like a variance, you are the finders of fact. You are a trial court. You are hearing evidence. Your duty is to review the record that is either presented to you and authenticated and admitted by the chair into evidence, hear the testimony, consider the documents, and in the end, hear arguments of the parties or their attorneys, much like a summation would be in a trial. You are to make one of the following decisions: affirm in whole or part the notice of violation or the matter on appeal, reverse in whole or part that matter, or modify that particular matter, the order that was presented by the town official. You have all the powers of the zoning official if you want to abandon completely and make your own order that may be appropriate. According to the evidence in the ordinance, you can do that as well. As in a variance, it is very important that your decision be complete with a full account of the reasons and the facts on which your decision is based. And by that record, either party who may be aggrieved by your decision can appeal even further to our courts. Your consideration of any appeal might necessarily mean that you need to interpret certain language and whether it has meaning in your ordinance itself. Accordingly, I give you this guidance. Your primary objective is to determine what the town council meant in adopting the language that is at issue. You should listen carefully to the arguments of the town and the applicant. You should examine the ordinance text itself. If it is clear, you should give it its clear meaning. If the ordinance provides definitions, consider that definition thoroughly. If the ordinance provides other interpretive guidance, you should use it. Contrast other provisions of the ordinance to provide meaning to a term or section at issue. Apply a logical meaning to words. Use a dictionary if necessary. Determine and give effect to the intent of the Board of Commissioners. That is the primary objective. Avoid absurdity. Ambiguity is resolved in favor of the property owner and in the free use of land. Mr. Chairman, I turn it over to you for any questions you may have of me.
Okay, I'm sure there's some questions for Mr. Wheelis.
Yeah,
Start with you, Tony.
this may not come up, but it's better to know ahead of time.
Now, by the way, we won't discuss anything particular about any application that you
No,
might
I'm
have
not, yeah,
before you.
this is general.
Yes, sir.
Since it's quasi judicial, hearsay evidence permitted.
Technically, no. It can be in your discretion. I'd prefer it not to be.
Okay,
Quasi means a lot of things. We try to hold tight to the formal rules of evidence, and I assist the chair in making those calls.
okay. How about chain of custody issues? If documents are presented.
We rarely have chain of custody, which is more of a criminal type issue, but we do have authentication. If a document can be authenticated, then it could be admitted into evidence if it's germane, relevant to the issue at hand. If it can't be authenticated, it is a hearsay document.
Jay, is there any, in the planning board side of our duty, we're able to discuss outside of the meeting with another board member? That's forbidden?
You should not do that.
Yeah.
Just the same as you would not want your judge to be talking to other members who may have some decision, some sway outside the courtroom. Ex parte, outside the courtroom communication should be prohibited, including communications with either party.
Right.
I had another question, but it escaped me. At 2:00 in the morning, I'll tell you.
Yeah.
I'll give you a call.
Shoot me an email. I'll get back to you.
Okay.
We're all sworn in, right?
I'm sorry,
We
ma'am?
are all sworn as well, sworn in?
No, ma'am.
No.
No, only people wishing to testify and be subject to cross-examination who might offer evidence would be sworn as witnesses.
I just woke up.
Yes, sir.
North Carolina law, I believe, and clarify this, if a person is presenting their case, unless they have an attorney present questioning other people, is that permissible?
Absolutely.
So you don't have to be an attorney, because I was at a Board of Adjustment hearing a couple years ago where somebody wanted to ask questions and they were told because they're not an attorney, they couldn't ask the questions in representing another person. In other words, they're not an attorney, but they go up there and representing.
Let's give an example.
Mhm.
Let's say it was a surveyor or a land planner, non-attorney.
Mhm.
And oftentimes they are here to present. They cannot make any arguments, cannot cross-examine a witness. So that may have been the situation.
Yeah.
I'm not familiar with it, but a party, if I were the
Yeah,
aggrieved,
The aggrieved party.
I can ask the questions until the cows come home because I'm the aggrieved party, as long as my questions are relevant and not meant to inflame and so forth.
Yeah, but the aggrieved brother cannot do cross-examination. or-
Correct.
Okay, that's what I was.
Unless he is an attorney acting as the attorney for the aggrieved party.
Right.
Yes,
okay.
sir.
Jay, I've got your admonition to the public in front of me.
Yes, sir.
You want to give us,
I don't recall what it was. Help me out. Oh, is this about,
this is not a legislative public hearing where the public is invited to give.
Yes, sir.
opinion. So I guess it would be,
He can bring it
would
up.
you make that presentation?
I would normally, I wouldn't do it now.
Right.
But at the beginning of a meeting, particularly meetings that might have some emotional flair to them, it's proper to set the right tone.
Right.
There you go.
Yes.
Yeah, there you
And,
go.
and a lot of this has to do with who can be an aggrieved person, who can have a right to participate from the audience, because this is a hearing. You can't just walk into court
Sure.
and say, I want to talk. You don't get to do that unless you're a party. But we have parties who can be aggrieved because of the nature of the decision. It might affect them gravely. The person next door, there could be a financial impact, their views and things of that nature. And it is up to the board to decide whether a non-party, you've got the town and you've got the person against whom the decision has been made by the town. If there's somebody in between, it's up to this board to challenge them, not in a mean or aggressive way, but by examining them under oath, how it is that they claim to be an aggrieved person such that they can participate in the trial.
For example, an adjoining property owner or across the street property owner,
What about?
they are aggrieved.
Could be,
Civic Association?
could be,
Yeah.
could be, could be, but
But they have to be sworn.
It's narrow.
Once they come forward and say they feel that this decision is going to impact adjoining property, for instance, that person has to be sworn.
somebody's going to have to take the stand
Yeah.
and get examined as to why that may or may not be the case.
So who's notified on all this proceedings?
The adjoining property owners and the property owners themselves.
Of course, you have notice
And the-
published in the paper
and
to the general public as
and the-
well.
And the applicant, and when I was referring to letters, we actually send letters, a copy of the public notice to the property owners, adjoining property owners. And we also run a public notice in the Coachland Times once a week for 2 weeks.
And that, all of that is disseminated to the Board of Adjustment.
All of those proofs,
Everything that is sent out as notice is copied back to the board.
I'm not sure about copied, but normally they are in your board
Yeah,
packet
the packet.
as proof of
Right.
the board, the town staff having done all of their requirements
Uh-huh.
in terms of serving.
Now, do we get existing documents or prior to the meeting? That would,
I don't know how Wes usually mails them out. You normally would get them prior to showing up, but
Yes, we'll be sending out the materials. I think the ordinance says not less than 1 week prior to the hearing, but we'll make sure that you have them
everything? that
well
we-
in ahead of a week.
now that may not be all the evidence that is presented. It's just been what has been presented with the application or some things that the town wants you to see in advance to make up a full and complete packet to start.
In addition to the letters that of public notice, as well as the notice in the Coachland Times, we actually also post a copy of the notice on the site on a sign that says hearing, zoning decision.
No question. You're done. Are you finished, Andy?
Pardon?
Are you finished?
Yeah.
A couple of questions. One, the party who has been denied, who's appealing a claim, is there any restriction for them contacting the potential aggrieved parties? Reaching out to them?
No,
Okay. The last comment that you made having to do with ambiguity, would you read that again? Would you state that again?
the rules of law favor the free use of land. And if there are ambiguities, they generally need to fall in favor of the right of free use.
Thank you.
Comes from page 103 of David Lawrence's book, David Owen's book.
Can I ask the other board members if they are aware of the appeal that will come before them?
That's,
Are any of you aware of the appeal that's coming up?
In a rough way.
Okay.
I don't
Just
know
curious.
what, I knew there was something coming up. And
Just curious.
I was going to say.
and your question kind of falls on maybe a recusal line of questioning. One of the things.
And the comment that you made about crosstalk.
Yes, sir. One of the first things that we'll do at that meeting is ask whether anyone here has reason to challenge any of the members. Somebody could stand up and say, yeah, I've been talking to him for a week about it, or a month or a year. Or a board member could say, I have a definitive opinion on this that is unlikely to be changed, and therefore it is not fair to the aggrieved party that I sit. So we'll go through some of those maneuvers at first to make sure we've got a constitutionally valid and fair presentation for the aggrieved party.
Anybody?
Just send me the information.
All right. Well, I really appreciate your time. Look forward to working with you.
Okay, thanks a lot. I'm
Thank
sure
you. Good to see you, Wes. Yeah, thank you.
Thank you.
we'll have a question or two that Wes can relay to you, and you'll sort it out for us. Okay, thank you. Okay. All right. Well, we've got another public comment here. Does anyone wish to speak publicly or that hasn't signed up? None seen. Shut that off. Planning board member comments. I'll start with you, Linda, and work this way.
I have nothing.
Okay, thanks, Tony.
No, I don't have anything.
Thank you. I don't have anything.
Nothing here.
Too easy. Wes, do you have any announcements?
Yes, sir. The next meeting will be held on the hearing that Mr. Wheelis was referring to. We're still trying to find a date. I've been emailing you all back and forth, trying to find a date, but unfortunately, it's been difficult to find one that works for all the parties involved. Without considering that, the next scheduled meeting that you all have is September 19th, the regular meeting, and that'll be at 5 p.m. That may have on the agenda the Pleasure Palace zoning text amendment, Pleasure Property zoning text amendment application. And it may also include ZTA 2108 for signage. If you remember, we're working on that. Former town attorney Ben Gallup, he did provide us comments prior to his departure from representing the town. So we may be able to have that back in front of you again as well. Also, at the last town council meeting that was held on August 2nd, there was ZTA-2207. Council held a public hearing. The board had recommended approval, and council approved that ZTA as recommended by the board, and that was unanimous. And the board also approved the election of Mr. Ward, chairperson, Mr. DiBernardo as vice chairperson. With respect to ZTA-2207, I'll be sending out the adopted version of it once it's been signed. I don't believe the town attorney has been able to sign it yet. So we can't send it to Unicode. It's not official until we have mayor's signature, town attorney's signature, and town clerk's signature. So once we have all that, I'll send it out to you all.
Can you, I've done it and I should have written down the steps. It's fairly easy to get into the Unicode and dial back on what has been approved over. I mean, it's about a 3 or 4 step process, but you can see all the ZTAs that the planning board has and TCAs that have rolled through in the last couple of years. So if you can give direction.
Yes, sir. That's a good question. One way to find it, the town code, is to find Unicode. There's a link on the town website. If you look up on the screens, departments, planning and code enforcement, and then town code and charter. And this is the town code Unicode page. So if you look, as soon as you come to it on the left, you'll see chapters 1 through 36 zoning. And on this side of the screen, adopted ordinances not yet codified. The town clerk, once a ZTA has been approved, or any ordinance for that matter, they're sent to Unicode. And that's usually done, I think, maybe twice a year, once a year. 5-5? Okay. Until that happens, a scanned copy of the ordinance is posted on Unicode.
Mm-hmm. Yeah.
It still includes the strike throughs and the underlines, but the approved copy is there.
Yeah, and I mean, that's a great source for us as a planning board to be able to dial back in there. But I think we're all in agreement that as they get adopted by town council on our action, then you're going to start sending us a copy of the adopted ordinance.
Once we have it, yes, sir.
Right,
And I
okay.
think right now, it looks like there's about 8
Yeah,
ordinances that have not been codified yet.
Yeah. Okay, thanks. All right, well, you got anything else, Wes?
No, sir, Mr. Chairman.
Anybody mind if I adjourn?
I make a motion that we adjourn.
I'll second that. Adjourn. Thank you all for coming.